Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. This video we're going to be discussing maintenance of residency in the United States for legal purposes. So what are we talking about here? Well, folks that get a green card and are landed immigrants, or in some context they're either called landed immigrants or what are called lawful permanent residents in the United States. These folks, they can come and go from the U.S. There's nothing wrong with that per se, but leaving for a prolonged period of time can be problematic with respect to maintaining one's residence in the United States. What are we talking about here? Well, United States Customs and Border Protection is tasked with admitting immigrants as well as Americans into the United States at various ports of entry, both airports of entry, seaports of entry, land ports of entry, etc. One of the things the officers of USCBP look at when they're admitting someone who has lawful permanent residence is when were they last in the United States. If one has not been in the U.S. for a prolonged period of time, and we're usually talking about years, however, don't necessarily make the presumption that you have to be gone for 1 year or 2 years or something like this. There isn't really a hard and fast rule with respect to absence from the United States. More what the USCBP officers are looking at is circumstantial evidence pertaining to whether or not it's clear that that immigrant intends to remain a lawful permanent resident in the United States. So what you'll often hear is someone will say, yeah, as long as they're in the U.S. once a year, it should be fine. And it depends on circumstances. You know, somebody may be working abroad with a multinational company and have lawful permanent residence in the United States. And yes, in the long term, they intend to remain residents. But for the foreseeable sort of short-term future, they're working abroad, something like this. There are many different hypotheticals I can think of where one would need to be abroad for prolonged periods of time. That being said, there are methods of forestalling problems with maintaining residence, most notably obtaining what's called a reentry permit. There's a video on this channel which speaks specifically to U.S. reentry permits. Reentry permits are issued for a 2-year duration. Once issued, as long as someone has it and it's still valid, they can kind of come and go and be gone for a prolonged period without calling into question one's residential intentions. But that being said, if one is abroad due to extenuating circumstances beyond one's control and one believes that their residence may be called into question, it might not be a bad idea to check out what's called an SB1 returning resident visa. There's another video on this channel specifically dealing with the SB1. We urge folks who are interested in that to go ahead and check out that video. The SB1 can be utilized by a lawful permanent resident of the United States who simply wishes to obtain a new travel document, aka a visa, to go back and reestablish their residence, if you will, in the United States, or reestablish their domicile, maybe a better way of looking at it. But that being said, maintenance of residence is important. As I said, in the past, it was sort of looked at, oh, as long as you set foot on the soil once a year, you're okay. I've heard that colloquially stated many times. That's not necessarily the analysis. The analysis comes down to one's intentions and one's actions, which would denote one's intentions with respect to maintaining one's residence in the United States. A couple of things to keep in mind is those who are married to United States citizens who are working abroad in conjunction with, or in furtherance of work associated with like the U.S. government or the U.S. military. There are other sort of exceptions to the overall rule with respect to maintenance of residence. Those folks actually, under certain circumstances, like let's say the spouse of a U.S. citizen stationed outside the United States, that spouse, for all intents and purposes, will oftentimes be treated as if they're still in the U.S. for purposes of this sort of analysis, because the thinking behind it is, you know, this is an American citizen, they're posted abroad due to something that the government is requesting or is ordering them to do. If their spouse has to go along with them or does go along with them, even voluntarily, it's sort of a courtesy that's extended, for lack of a better term, by exempting that foreign national spouse to these sort of to this sort of analysis. But that being said, it's good to keep in mind that United States immigration is they do look at one's intentions with respect to coming and going from the U.S. while maintaining lawful permanent residence. And the final thing to think of, if one really doesn't intend to maintain their lawful permanent residence in the United States, there's a mechanism for dealing that. It's called an I-407 surrender of green card status. Upon surrender of one's green card, that individual no longer has rights to reside in the United States lawfully. But that being said, for those who wish to visit again, following an I-407 surrender, it's usually possible to go ahead and apply for a U.S. tourist visa. For information about that, I suggest checking out the videos specific to I-407 surrender and specific to U.S. tourist visas on this channel.